You're very familiar with the case of Albertus Lewis. Albertus Lewis allegedly shot Myra Sanchez in the head and then dumped her body in a wheelchair outside of a hospital in downtown Columbia. You granted Lewis a surety bond in the amount of $150,000. After you did so, it turned out that Lewis was involved in yet another violent incident when police responded to a domestic violence scene involving Lewis, where a woman called 911 saying Lewis had a gun and was setting things on fire. When police arrived, they had to fire almost immediately because of the danger, and they had to go in because Lewis picked up a small child and used a small child as a human shield, in the process causing injury to two sheriff's deputies. Do you think it was a mistake to release a violent criminal on bond when he went out and committed yet another violent crime?
Thank you, Senator.
Okay, did you just see that? Because I need a moment. What you just watched is Senator Ted Cruz going full prosecutor mode in what is supposed to be a routine judicial confirmation hearing, and Judge Benjamin is sitting there struggling to justify a decision that is very hard to defend. Here is where I stand before we watch the rest. I believe in due process. I believe every accused person deserves their day in court. But I also believe that when a judge releases someone accused of shooting a woman in the head and dumping her body outside a hospital, and that same person goes on to use a child as a human shield while injuring two sheriff's deputies, someone needs to answer for that. And Ted Cruz is making sure that answer happens on the record. What makes this clip stand out is that Ted Cruz is not just grandstanding. He comes in prepared. He knows the case details. He knows the Fourth Circuit precedent. And he is not letting Judge Benjamin hide behind vague constitutional language. I want to watch the full hearing before I give you my complete take, but before we do that, if you are new here, hit subscribe and turn on notifications because this is exactly the kind of content we cover. Drop a comment right now with your first reaction to that clip. Did Ted Cruz land his point? Let me know. Let's get into it.
Cruz?
Thank you, Mr. Chairman. Judge Benjamin.
Good morning.
Good morning. There has been considerable discussion nationally about policies of Democratic district attorneys and Democratic judges releasing violent criminals who in turn turn around and commit more violent crimes and make our communities less safe. This has been a problem plaguing the country as we've seen crime rates skyrocket and murder rates skyrocket. And it is a problem that is exacerbated by the Biden administration and the Democrats in the Senate, who continue to further the priorities of releasing violent criminals. When I look at your record, I see a pattern of doing the same thing. You're very familiar with the case of Albertus Lewis. Albertus Lewis allegedly shot Myra Sanchez in the head and then dumped her body in a wheelchair outside of a hospital in downtown Columbia. You granted Lewis a surety bond in the amount of $150,000. After you did so, it turned out that Lewis was involved in yet another violent incident when police responded to a domestic violence scene involving Lewis, where a woman called 911 saying Lewis had a gun and was setting things on fire. When police arrived, they had to fire almost immediately because of the danger, and they had to go in because Lewis picked up a small child and used a small child as a human shield, in the process causing injury to two sheriff's deputies. Do you think it was a mistake to release a violent criminal on bond when he went out and committed yet another violent crime?
Thank you, Senator. As I previously stated, Mr. Lewis, when he initially appeared before me, I denied his bond. It was not until after the state violated the court's order to try his case. There was issues with discovery missing in the case. And Senator, I'll just say this, the case is still pending. It's a 2017 case. It is still pending. There's issues with discovery in the case, and the defendant was asserting his right, Sixth Amendment right to a speedy trial. That was after 2 years when he initially appeared before me, and I denied his bond. In considering any bond, Senator, I consider the United States Constitution, the South Carolina Constitution, and I have to consider the bond statute of the General Assembly in South Carolina.
Okay, so you just said you did it because of a speedy trial claim. What is the remedy for a speedy trial claim?
The remedy for a speedy trial claim is dismissal.
So you didn't do that, did you?
My consideration was based on him violating the court's previous order of not trying the case. It was
By the way,
not
what's
based-
the Fourth Circuit precedent on speedy trial claims? And isn't it in fact the case that the Fourth Circuit has repeatedly held that substantially longer delays don't violate the speedy trial clause?
Well, I think there's an analysis that has to be done.
Did you engage in that analysis?
Yes, and part of that analysis is that the state has to give a reason as to why they did not try the case. And in that case, the state did not have a reason
So
whatsoever.
you said you engaged in that analysis. Did you write an opinion? Did you explain your reasoning from the bench?
I don't recall. I do not recall, but we do not usually have published opinions in South Carolina.
Well, you know, the court they've appointed you to, that's what they do. And
yes, I understand that.
so I'm going to give you a chance to answer my question again, because I started with, do you think it was a mistake to release a violent criminal who turned around and injured 2 sheriff's deputies and held up a little child as a human shield? Was it a mistake?
Thank you again, Senator. Once again, I consider the issues before me. I consider the Constitution of the state of South Carolina, the United States, and the bond code. And
But
I
you
made
know,
my
that's not any
based on
comfort
that.
to the families of the sheriff's deputies who were shot by the violent criminal you released. And you have a pattern of doing so in other cases as well, including releasing one of the people involved in yet another murder of Kelly Honeywell, a 33-year-old single mother of 4 who was murdered, shot during a robbery, and you released one of the individuals involved in that. And listen, what I find amazing is the Biden administration claims they bear no responsibility for releasing violent criminals who turn around and murder people. But then President Biden keeps nominating judicial nominees who have a history of releasing violent criminals who turn around and murder people. And every Senate Democrat's going to vote to confirm you, and they're going to go home and tell their constituents, oh, we don't support releasing violent criminals who turn around and murder people, and yet we keep following this pattern over and over again. There's a reason people are very concerned about the safety of their families.
All right, we just watched the whole thing. Here are my thoughts. Ted Cruz walked into that hearing room having done his homework, and that is exactly what this process is supposed to look like. A confirmation hearing is not a rubber stamp. It is a vetting process, and Ted Cruz treated it like one. Let's talk about the Albertus Lewis case because this is the heart of everything. Lewis was accused of shooting Myra Sanchez in the head and dumping her body in a wheelchair outside a hospital. Judge Benjamin initially denied bond. That is the right call. But then Judge Benjamin reverses and grants Lewis a $150,000 surety bond, citing the state's failure to meet discovery deadlines and Lewis's Sixth Amendment speedy trial rights. Here is the problem, and Ted Cruz nails it. The constitutional remedy for a speedy trial violation is dismissal of the case, not bond reduction. That is settled law. When Ted Cruz pressed Judge Benjamin on Fourth Circuit precedent, which has consistently held that substantially longer delays do not automatically violate the speedy trial clause, Judge Benjamin could not point to a written opinion, could not recall whether he explained his reasoning from the bench, and could not clearly justify why bond release was the right remedy instead of dismissal. That is a problem, not because judges are expected to be perfect, but because a federal appellate judge must be able to articulate their reasoning and defend it under pressure. If you cannot explain your decision in a confirmation hearing, How are you going to write federal opinions that set precedent? And what happens after Lewis is released? Lewis shows up at a domestic violence scene with a gun, starts setting things on fire, and when law enforcement arrives, grabs a small child and uses that child as a human shield. 2 sheriff's deputies are injured, a child is traumatized, and the man accused of murder was walking free on a bond decision that, by Ted Cruz's legal analysis, was questionable from the start. Ted Cruz then brings up the Kelly Honeywell case, a 33-year-old single mother of 4, shot dead during a robbery, with Judge Benjamin having released one of the individuals connected to that murder. At that point, it stops being about one bad call. It becomes a pattern. Now, I want to be fair. Judge Benjamin is clearly composed and intelligent. Judges do have to operate within constitutional constraints, including defendant rights. I get that, but composure is not the same as sound legal reasoning, and the refusal to directly answer a straightforward question is telling. Ted Cruz asked Judge Benjamin twice whether releasing Lewis was a mistake. Twice! He gave Judge Benjamin every opportunity to show some humility, to say something like, given what happened, I would have approached it differently. That answer would have shown self-awareness. Instead, Judge Benjamin gave the same scripted response about the Constitution and the bond statute both times. That is not judicial temperament. That is avoidance. Ted Cruz's closing point deserves serious reflection, no matter where you stand politically. There is a pattern of violent individuals being released pre-trial, going on to commit more violence, and the people responsible for those decisions facing zero accountability. When the people nominating and confirming these judges keep insisting they are tough on crime while voting for judges with records like this, that contradiction should bother everyone. Ted Cruz did exactly what a senator is supposed to do in a confirmation hearing. He asked hard questions, cited specific cases, knew the law, and gave Judge Benjamin every chance to defend his record. Judge Benjamin could not do it convincingly. Public safety is not a talking point. The families of those 2 injured sheriff's deputies are real people. The 4 children of Kelly Honeywell who lost their mother are real people. Myra Sanchez was a real person. If you made it to the end, drop a scales of justice emoji in the comments. I want to know who is watching and what you think about judicial accountability. If this gave you something to think about, share it, because these conversations need to happen everywhere, not just in Senate hearing rooms. See you in the next one.